Good afternoon, friends. Welcome to MAYCHAM's webinar today. Well, this is some very interesting topics. We will be speaking from very experienced people, Sanisa and Alex. Welcome. This is a webinar that MAYCHAM is co-hosting together with the Swedish, the Singapore, the Irish, the Dutch, the Canadian, and Belgium, Luxembourg Chamber of Commerce. Welcome, everyone. And I will pass this to Sanisa, who will take it over and get the topic moving. Thank you very much, and enjoy the afternoon.
Good afternoon, everyone. Thank you, Chairman, for your introduction. For those who don't know me, my name is Sanisa Othman. I'm head of the Interchamber and Partnership Committee at MAYCHAM. COVID-19 has impacted us in many ways that we could not have imagined. During these difficult times, we've been confined to our home and have had to grapple difficult decisions like life and death. And it's also made us reflect on what is important and how to plan for succession and inheritance. We're pleased today to have Alex Liu talk today about wills and guardianship. So Alex is a partner at Boase Cohen Collins. Outside his law practice, he's an active volunteer with Alliance, Club International, and also the Hong Kong Guide Dogs Association, excuse me. And he volunteers sometimes with many Hong Kong organizations, including the Guardianship Board. I met Alex 20+ years ago when I relocated from London to Hong Kong. My then head of chambers, the late Anthony Scrivener QC, asked me to look up Boase Cohen Collins because they were one of the best firms in Hong Kong. Alex is a MAYCHAM member, and one of the reasons he joined MAYCHAM is for his love of durians. And this is a great segue for us to get into today's talk to discuss the thorny issues of wills and guardianship. So a couple of housekeeping matters, please. The format of today's talk is Alex will present, then it would be followed by a Q&A. Now, as you are listening, please feel free to type in your questions into the Q&A box, and hopefully we can address your questions. Without further ado, please welcome Alex Liu. Floor is yours.
Thank you, Sanisa, and thank you, Chairman. Please. Ladies and gentlemen, welcome and thank you for having me here. I'm grateful to the organizer MAYCHAM and all the co-hosts, including Belgium, Luxembourg, Canadian, Dutch, Irish, Singapore, and Swedish Chambers of Commerce for this opportunity. Right. Yes, as outlined in the invitation to you all, we will consider three main topics. It's not moving. It's already. Okay. First, the advantages of making a will. Second, the steps you can take to protect your children's future. And third, matters we should consider in looking after our aging parents. Before I begin with my presentation, let's do a poll question. The question is, how many of you are planning to write a will? There are three choices: certainly, unsure, and never crossed my mind. Are we done with the poll?
Mm-hmm. So Well, it's closing.
Yep, the poll is closing. Thank you very much. As responsible and successful adults, we would like to make plans for the care and maintenance of our children and parents. In an age of uncertainties and unknowns, for example, the COVID-19 pandemic, economic and political forces, there is a greater need to act now. You want to announce yourself? All right. Now, let me just tell you a bit of the results here. How many of you are planning to write a will? We've got 75% certainly, 19% unsure, and 6% never crossed my mind. Okay. So coming back. We often hear people using a trust or a will to make gifts. How do they work? Is there any overlap between the two? If I want to give my son an apartment when he reaches 25, what should I do? Shall I take steps now or later? What are the differences? Living gifts. Let's go through some basics regarding gifts. The first thing to consider is what we call living gifts. Example, I give my adult son a watch. I make it clear that it's a gift, or I give him an apartment. I can either buy it in his name or execute and register an assignment in his favor. In both instances, the watch and the apartment become his property. These are gifts with immediate effect. I cannot claim them back. However, I may wish to announce my intention to give the watch and or apartment, but they will be handed over to my son later. In this case, I need to make a trust arrangement whereby the gift is passed to a trustee, a third party, who will hold it in trust for my son until an agreed date or occurrence of a certain event. To make multiple gifts to be effected later, I need to execute a trust document appointing the trustee and setting out the terms of the trust. Usually a trust deed will be made and $1 will be paid into the trust, such that the trust is at law properly constituted. The settler, that is me, may then take time to transfer assets into the trust according to my timetable and wishes. The above are inter vivos gifts, meaning in Latin, between the living. So these are gifts made during a person's lifetime. So let's consider the advantages of making a will. The alternative to living gifts is a testamentary gift, usually via will, which only comes into effect upon passing of the testator, the person making the will. A will can be amended or replaced at any time. A will may contain gifts which are to take effect immediately upon death, and it may also contain future gifts by incorporating a trust arrangement. So to answer the questions that I posed earlier, let's see. If I want to give my son an apartment when he reaches 25, what should I do? Suppose it's an existing apartment in my name and my son is only 10 years old. Option 1, I may execute a deed of assignment to a third party and simultaneously a deed of trust appointing him as trustee to hold the property on trust for my son and to transfer the property to my son on his reaching 25. But since stamp duty is payable on the transfer by me to the trustee, and the amount can be fairly substantial nowadays, this may not be a good option. Option 2, I may write a will containing a specific gift of the property to my son but the gift is not definite because it may lapse or fail if in the meantime I dispose of the property or change the will by removing the provision. Option 3, I may wait and take step sometime later, but if I lose the mental ability to act or die unexpectedly at any time, I may not be able to deal with the property according to my own wishes. So how do I make a will? Consult a legal professional, I would say. Do not try to do a homemade one. This will give you peace of mind and avoid legal pitfalls. This is especially true if your estate is considerable or you have multiple family members. The choice of executor and trustee in the will is important since he has important responsibilities. The executor is the person, often the main beneficiary, who executes the will, that is, to ensure all the wishes and specified actions are carried out. Since a will invariably incorporates some form of trust arrangement, the executor often acts in the capacity as a trustee as well. In appropriate cases, professional trustees may also be appointed. In the will, you may leave specific gifts to individuals or organizations. You may also divide your assets by proportion. You may do a combination of the two. For example, you may appoint your wife as executrix and give her the matrimonial home, your son all listed bonds and shares, your daughter all private company shares and equity fund units. These are specific gifts. And give the residuary estate worldwide to your wife as trustee to hold on trust for herself as to 50%, your son 20%, your daughter 20%, and maybe Tonghua Hospital 10% beneficially. It is important to also note about the residuary estate. These are the assets that are left over after all specific gifts are bequeathed and debts, costs, and fees are paid. Let me see. So, yes, gifts that cannot be passed to the person specified in the will, perhaps due to their own death or other reasons, fall into the residuary estate. I appreciate a majority of the audience are Malaysians by origin, and many of you have been residing in Hong Kong for years or even decades. You may have children in Hong Kong and assets in Hong Kong, Malaysia, and elsewhere. What are some of the major issues you should pay attention to when making a will in Hong Kong? Domicile is a complex area of law that is extremely fact-sensitive and has potentially far-reaching effects on the future distribution of your wealth. In Hong Kong, domicile is governed by the Domicile Ordinance. Under the ordinance, every person has a domicile and one domicile only, which can come in two forms: domicile of origin and domicile of choice. A person's domicile of origin from birth follows his or her parents' domicile, save in rare situations where the parents have different domiciles and live separately. The domicile of origin is retained until a new domicile is acquired by choice as an adult. A domicile of choice is, as its namesake implies, acquired through a person's voluntary acts. For instance, the law allows you to acquire a domicile in Hong Kong if you are physically present in Hong Kong and demonstrate the intention to make a home in Hong Kong for an indefinite period of time. It is important to note that the indefinite period is a crucial element of the intention. Hence, if you are an expatriate who is in Hong Kong for work but fully expect to leave once your duties are completed, then you would not be considered to have acquired a domicile in Hong Kong. Why should we be concerned? Whilst a person's domicile might not have a significant impact on a person's daily life, there are several issues that may surface once he or she has passed away. Under Hong Kong law, succession of a deceased person follows the law of the place of the deceased domicile. The probate registry in Hong Kong also requires additional formalities and papers to be filed when dealing with cases where the deceased died domiciled outside Hong Kong. And the effect also goes further. Intestacy laws vary between jurisdictions, and if a person dies intestate in Hong Kong but domiciled elsewhere, his or her assets may be distributed in accordance with the law of the place of domicile, notwithstanding that those assets are all located elsewhere, potentially adding another degree of complexity to estate administration. The exception is with regards to real property, which follows the law of where the property is located, regardless of domicile. Hence, laws of the countries where real properties situate are relevant. In some jurisdictions, a gift by will of a property may be invalid if it is not made to the testator's spouse. Another exception which may be of interest is that in Hong Kong, we have the inheritance provision for family dependence ordinance, which is to make provision for empowering the court to make orders for the making out of the estate of a deceased person of provision for certain members of that person's family and dependents of that person, and for connected matters. So what it means is that this ordinance or the provisions may be invoked if a son or a companion of the deceased, or even a carer of the deceased, used to be maintained by the deceased, but is somehow not named a beneficiary in the will or not covered by the law of intestacy. So an application may be made under the ordinance for provision for maintenance. Let's look at a couple of real-life examples of succession issues I have dealt with. I want to, well, as an example, I want to buy an apartment for my daughter's family to live in, but I'm worried she may divorce her husband soon. How should I do it? In fact, the real life situation was that the daughter, upon execution of the assignment of the purchase, told me his relationship with her husband was difficult. The purchase money had come from her father. Therefore, she did not want the property to form part of her family assets for distribution in the event of any divorce. Well, this required some out-of-the-box thinking. I suggested we could make the money from her father resemble a loan. However, instead of a lengthy and complicated loan agreement, I believe a one-line IOU plus regular repayments would be more realistic and also would serve the purpose. A real lending arrangement will entail regular repayments. To make repayments for, say, the next 36 months, she should obtain an extra lump sum from her father. Since this was a one-off lending transaction, her father would not be deemed to be carrying on a lending business, so would not require a money lender's license. If the marriage survives another 36 months, perhaps no extension of the repayment arrangement is required. Here is a second case I have dealt with. My son is insisting on marrying his girlfriend, but I don't think she is suitable for him. I have strong doubts about her. I wish to reduce what I leave him in my will. So this is, again, a real-life example. Now, in this instance, it would have been much too complicated to provide for contingencies in his will, i.e., if the son is married with his existing girlfriend, when the will comes into effect, he receives X. If he is married with someone else, he receives Y. If he is still single, he receives Z. I simply advise the client to amend the percentages in his will as and when necessary according to the son's circumstances. The nice thing of a will is that you can change it anytime. The above are situations where we have made appropriate plans. What if we have not done so? What if I have not made a will? If one passes away without a will, not only does this make life more complicated and stressful for surviving family members, it leaves you at the mercy of the state. In Hong Kong, your assets are distributed according to the Intestate Estate Ordinance. Roughly, your estate is distributed with the following priority: spouse, children, legitimate and illegitimate, parents, siblings, grandparents, uncles, and aunts. I give you another example here. There is a husband and wife, long marriage with no children. The husband passes away intestate, while the wife thinking that everything goes to her, but she suddenly faces claims by her deceased husband's siblings. Based on what? Section 4(4) of the ordinance, which provides that if the intestate leaves no issue, but does leave a wife and one or more of the following, namely a parent, a brother or sister of the whole blood, then the surviving wife shall take the personal chattels. Absolutely, and in addition, the residuary estate of the intestate shall stand charged with the payment of 1 million free of death duties, but in Hong Kong, we don't have death duties, and costs to the surviving wife with interest thereon. And then the estate shall be held as to 1/2 in trust for the surviving wife absolutely, and as to the other half, where the intestate leaves no parent, on the statutory trusts for the brothers and sisters of the whole blood of the intestate. So you see how this comes in. This could cause complications, stress, and possibly legal proceedings. So I'm on to part 2 now. How do you protect your children's future? How do you protect your children by appointing guardians? The testator may include in his will an appointment of a close friend or relative as guardian for his young children upon his death. Of course, If he has a young son studying abroad and he wishes to make an immediate guardianship appointment, he can execute such an instrument right away. By the way, an appointment of executorship or guardianship can also be passed on by will. So a point to bear in mind, also an added benefit to have a will drafted or written. In other words, guardians should be appointed by the parents in either a will or a deed. A deed may be more ideal as it allows guardians immediate access to the children and can be kept as an original document by the guardians for record. The original will in such an unfortunate event will likely be probated in the Hong Kong courts, and the guardians will no longer be in possession of an original document to show their office appointment as guardians. Their official appointment, sorry. Parents and current guardians can appoint other people to act as future guardians, as I said, in a will for their children who are still minors in the event of death of both parents or the current guardians. In addition, covering the children's basic needs, such as their living and medical expenses, such appointments will require the need to take into account the views and opinions of the children, especially when the children are reaching the age of majority and have the capacity to make decisions on their own. I'm now on to the third part of this presentation, which is, what does guardianship of an elderly parent mean? This brings us to the question of mentally incapacitated persons. For example, there are 4 main types of disabilities of mentally incapacitated persons: dementia, Alzheimer's disease, major cognitive impairment, mental handicap, mental illness, or acquired brain damage through an accident or illness, such as a stroke. In the event this happens to the donor, an ordinary power of attorney or authorization ceases to be effective. The donor of power can no longer act. For example, operate a bank or securities account on behalf of the donor and account holder. Since 2010, Hong Kong has led the world in life expectancy for both men, 82, and women, 86. It also means we have one of the fastest aging societies in the world. Hence, there is increased possibility that you might live through a prolonged period despite experiencing deteriorating mental capacity. Last week, I had a lunch with a friend who is into medical field and also medical developments, breakthroughs. He told me that he expected himself to live up to 150 years of age. So there we are. This is why more and more people are now implementing enduring power of attorney, EPA. Without an EPA, a court order, which can be expensive and lengthy, is usually needed to access the finances of the incapacitated person. I'll give you another example here. A wealthy father provides financial support to his son and daughter and their families. His will gives all assets to his wife. The father passes away, leaving a few $100 million worth of assets. But soon afterwards, the mother becomes mentally incapacitated. Therefore, An application has to be made under the mental health ordinance to the court for the appointment of a committee of the estate of the mother for the care and maintenance of herself, as well as her children's families. The official solicitor will be served with the papers and will raise requisitions to ensure the application is well supported. It is time and cost, it requires a lot of time and it costs a lot of money. For elderly people who are not so well off, but have a few $100,000 sitting in bank accounts, on becoming mentally incapacitated, their family members often, with the assistance of social workers, apply to the Guardianship Board to act as guardians. I am a member of the Guardianship Board and from time to time preside over hearings. We receive evidence and make guardianship orders, appointing applicants as guardians for the welfare and maintenance of elderly citizens, with power to transfer up to a maximum of $18,000 per month. I think it's time that we may deal with the second poll question. And the question is, let me see. How many of you will prepare a will now? 1, most likely. 2, unlikely. Yes, I've got the result so quickly. We've got 81% most likely and 19 unlikely. I think we may have done the poll questions at one time rather than at different times. Is that right?
Yes.
Yeah, and that's why we have these results. But anyway,
Can we do it again?
do we want to do it again?
Let's.
I'm reminded that I have to hide my face during the Q&A session. Yes. Do we have a different poll result, or it's still the same? How are we on time? All right. Oh, so this is the, how likely are you to create a will now? Oh, so the figures have gone up. We now have like
Yeah, good.
95% most likely, 5% it's jumping.
And tell people we got 30 seconds.
Yeah.
So we got 30 seconds.
Yeah, I'll wait for a few seconds to let it stabilize. Right. Yeah, okay. So we have like 93% most likely and 7% unlikely. Yeah, so let me give every one of you a round of applause. So I guess ready for some questions now.
Thank you, Alex. So as we're getting comfortable here, I'm going to stop the PowerPoint, if that's okay.
Yes.
So I think, Alex, you've done an amazing job because the numbers have come from 75 to 95. So that was a very fruitful discussion from your part. So thank you very much for that.
Thank you. Yeah. Also, I would like to ask what are those 75% people thinking? Because if they are thinking to do a will, what have stopped them from acting immediately?
That's a great question. And hopefully people can comment. Unfortunately, we're in a webinar format, but hopefully we can get people to write in their thoughts and comments. So actually, this is amazing because as you've been speaking, I think that you've done an excellent job to bring up a lot of questions from the audience. And there's a lot of questions. But as the moderator's first right of privilege to ask questions, I hope you will permit me to allow to do that.
You're very welcome.
So there's a lot of so I think you covered and touched on quite a number of things, but bearing in mind that this is the Malaysian Chamber of Commerce and a lot of our, sorry, I should say there are also other chambers who've dialed in, we share something in common in that we are largely based in Hong Kong, but we have other jurisdictions there that we have assets in. So with that in mind, what advice and recommendations would you give individuals with assets in multiple jurisdictions? So primarily in Hong Kong, perhaps with a bulk of their wealth, because that's just where they earn, and then with other, maybe you could give some advice, recommendation.
Thanks, Sunisa. It's a very good question. Actually, what I can tell is that administration of any real property overseas is subject to the law of the country where the assets locate. In this case, many of you, Malaysia. A relevant question would be whether a will made in Hong Kong is recognized in Malaysia. You are therefore strongly advised to seek advice from Malaysian lawyers on the succession and administration of estate there. You're also advised to make a separate will in Malaysia to deal with properties you own there. When preparing a will in Malaysia, please inform your lawyers that any will you made in Hong Kong and ask them not to revoke the Hong Kong will.
That's a great question. And that's a great question that you bring on about revocation of will. So something that crossed in our mind as we're talking about wills is how often should we be updating the will? Because as you point out that scenario where you've got two wills and then your will is constantly being changed, assets come, assets go. So what are your thoughts on that?
Well, I think since wills are relatively easy to be updated, you may do it when you feel free to. I would say when there are substantial changes in your family or in your assets, because maybe you have made specific gifts in the will as to a property. And then if you have sold the property, the specific gift will have lapsed, and you will have to replace it with something else.
That's good. Some good advice there for us to take away. So I'm going to keep an eye. Let's maybe go to our questions that we have here. Perhaps we can start off with a question about someone without family, because we've been talking a lot without family. And so what about single people without spouse or children? What are their important considerations in making a will?
I think we all work very hard in our lives, and we have accumulated certain wealth of our own. How we want to distribute our assets after passing is a question worth considering. With no will, that means we have to follow the law of intestacy. And if the domicile is Hong Kong, then we follow Hong Kong law. And if what is provided in Section 4 of the ordinance does not match our desire, then we will have to consider strongly that we make our own will.
That's a good point. You worked hard and you want to have full control of
That's
where
right.
assets are going.
Yeah, that's right. Otherwise, it will be a very difficult task of those surviving us, because they have to go through the whole process, dig out all the close or not so close relatives, find them out, and make sure the what's provided in the ordinance will be complied with.
Great. So moving on, I think let's maybe talk a little bit about the assets in the will. Oh, I see a attendee also has a similar question here. Maybe we can do it. So what kind of things can you put in the will nowadays? Because I know that you've got all sorts of things. You've got cryptocurrency. I think you flagged up.
Right.
You've got fur kits. I know pets are so important. We can see during COVID now, you go through all lengths to protect them. And you've got art collections, the collections of any sort.
Right.
So what kind of items can you put in the will? And what happens, I'm tagging on the question here, if something's accidentally missed out, how do you handle that?
Well, now, what can you put in the will? So basically, all your assets may be put in the will. You may, as I explained, you may make specific reference to particular assets, or you may just group them all together, let them fall within the residuary estate. So basically, when we look at assets, they may be classified into two categories: real property or personal chattels. Real property, real estate, property here and there, everywhere. Personal chattel, meaning it includes all physical or even virtual things, a pen or crypto. So it has all things not real property will be personal chattel. And then for you to consider whether or not to make specific reference in the will, you cannot name all your assets in the will, right? Because it will be too long and you may leave out. So you only put in the will what you consider important. You want to make specific reference. And also, from the point of view of administration of estate, people tend to take a pragmatic approach. Let me put it this way. I may not have mentioned a watch that I own in the will, and then that watch, my son may like the watch. So on my passing, then whether we take the watch as my estate, part of my estate, or we treat the watch as my son's watch. See what I mean? So there is a gray area. So when we are talking about assets which are not substantial, not too valuable, then we may do the easy way. But if we are talking about very valuable asset, then obviously we have to, when going through probate, we the executor or executrix will have to fill in the form and to state all the assets left by the deceased. And also we should consider there may be assets that are under registration. You mentioned fur kits. So pets may have to be registered under a certain name. So if it's under the deceased name, then obviously it's part of the estate, and it will be it will follow whether you have a will or whether the law of intestacy says.
Okay, that's great. That's great. Thank you. So I'm just turning back to our hand here for some more questions. There is a some overlap, but I'm going to see There's a question here. Why would my husband make a will to leave assets to children if the husband's parents, siblings can make a claim under the inheritance law you talked about? So maybe you want to take that on. I think.
Okay.
I
Now
think that's why you need a will, perhaps.
that's why you need a will.
will.
So when you make a will, then everything will be clearly set out.
Right.
All right. The inheritance provision of family members ordinance that I mentioned is a residual sort of protection for those who are left out.
Right. Right.
And it's only for maintenance, so it's not very much. And also there are prerequisites to an application. The person applying has to be maintained by the deceased for the last 3 years.
Okay.
If you don't have evidence to show this, then there is no basis to apply.
And is that a difficult barrier to prove? Do you need
there has to be evidence acceptable by the court.
Okay.
Yeah, that the person has been maintained in the last 3 years
So it's
by
very
the deceased.
It's very objective. It's not subjective.
That's right.
That's right. Great. So I think we've answered that live. Let's do that. Now, sorry, I think there's been so many questions, so we'll have to try and go and do that. Something that I answered that live. Okay, maybe a good question to go on to is there's a couple of questions about assets in different jurisdictions. So can we maybe jump to domicile, the issue of domicile? I think that you touched on very lightly. Before you get away, something I wanted to ask is why would you choose Hong Kong to be domiciled? And how could you choose that? Assuming you are a multi-jurist, I don't like to use that word, but you are most participants here work in Hong Kong, have a causal connection here, but then they have perhaps homes elsewhere. So maybe we could tackle that issue of domicile. Why would you choose Hong Kong? How do you choose Hong Kong? And what happens if you have assets outside of Hong Kong?
Right. Another very good question. Now, I deal with the why first.
Yes.
So what are the benefits of being domiciled in Hong Kong? Under Hong Kong law, succession of a deceased person follow the law of the place of the person's the deceased domicile. So if you have chosen Hong Kong to be your domicile, then on passing, then the Hong Kong law applies to the succession issues. In Hong Kong, estate duty has been abolished since 2006. That said, estate duties for foreigners may still be relevant.
Yes.
So and mind you, there are exceptions as I highlighted in relation to overseas properties, because properties will follow the law of the countries where the property is situated.
Right.
And domicile is often linked to tax residency as well. And a person who meets the criteria of being domiciled in a certain jurisdiction is likely also to be considered a tax resident of that jurisdiction. Some jurisdictions may have worldwide tax regimes in place, including inheritance taxes, and a person dying domiciled in such a jurisdiction would be subject to worldwide inheritance tax, despite those assets being located elsewhere. So that may give some ideas to why. And then how? One convenient way is to make a Hong Kong will and state in the will that you are domiciled in Hong Kong. Of course, it's a subjective statement, it's self-serving. So it has to tie in with the objective facts. In other words, if judged objectively from all circumstances, the testator has no real ties or intentions to make a home in Hong Kong, the statement of intention may be disproved. So I can give you a non-exhaustive list of factors that can be considered
Okay.
like a length of residence,
Right.
Condition of residence, whether you live in a purchased or rented property, workplace, location of business interests, property and investments, tax residency, just mentioned, marriage with a local partner, locations of family members, particularly spouse and children, membership and involvement with local organizations, yeah, the MAYCHAM here,
Right.
yeah, and other chambers as well,
Right.
and some form of official declaration of domicile or residence.
Oh, so the
Yeah.
declaration that
Yeah,
I
you
am
can make a
domiciled.
declaration, but again, like the one statement in the will is self-serving.
Right.
So you cannot have no tie and make a declaration hoping that people will uphold it.
Right, right. I see. Okay, interesting. So I see a few questions on trust here, and I think it would be correct for us to answer. And I see one situation. When do you need to set up a trust?
When?
Yes.
Well, it's a personal question. So it's you set up a trust because you want to make a gift, but you don't want the beneficiary to receive the gift immediately. That's why you want a trust. All right. So it's that's the basic idea. Otherwise, you will just give directly.
And I guess then you would go to. That would be okay. Maybe, but we'll leave it at that. Actually, I think we've answered the question. Let's see here. There is a question. Actually, maybe I'd like to ask a question touching on your expertise here, because you serve on the board, the Guardian Board, and this is a great opportunity for us to ask what's a good case example that you'd like to share with us, some interesting learning points.
Well, if you ask me this question, I think immediate to mind, I remember a case in which first of all, we are not dealing with wealthy families. So the poor old elderly was very sick, and then the daughter was so she had to give up her plans to study abroad, stay in Hong Kong to take care of the mother. I think that impressed upon me, and I really felt her love for the mother. Yeah, because some people make applications of that nature for money. So yeah, let me be clear. That's you apply under the mental health ordinance, either for an order for money or for the care and maintenance of the old people. So it would be up to the applicant to really think carefully what is the objective of the application. Yeah, from the board's point of view, of course, we stand to safeguard the interest of the elderly. We want to make sure that the order will serve the best purpose, the best interest of the elderly.
So thank you for sharing your story there. There seems to be quite a few trustee questions that probably we should look at. Let me see. I'll combine them if I can in the interest of time. So what happens if the trustee or the trust administrator goes out of business before it's time to execute the trust? And what happens if the trustee is not as professional as one thinks? I think you could combine that. Or
yeah. Now, if there is only one trustee, then if the trustee fails to act, then poor. I mean, we will have to see what else is in the trust document to deal with this eventuality. Now, hopefully there is more than one trustee, so the other trustee can act. Another way to think of it is a trustee may also pass on the duty of a trustee by by a deed or a testamentary instrument.
Mhm.
So if he foresees that he cannot act in the near future, then he should make plans for it.
Sound advice there. Great. So we've asked some more. Do we have time for one more question, perhaps? I know that I think we've touched on wills, touched on trusts, we've touched on the elderly, but I think there's something about children that I'd like to touch. So many of us, I think, including yourself as father, and they have children. So what advice would you give to people who have poor parents here with no immediate family in Hong Kong? What should you do? With COVID, it's taught us that things can happen very fluidly. So what advice would you give?
I think it's sensible to have a will, and in that will, you have an appointment of a guardian for the children. So just in case of passing, then somebody will be able to take immediate care of the children. I think that's advisable. I did it myself. Yeah, when I had my kids, right from the time when they were born.
Great advice. And to revisit that constantly, because assuming that something may happen to the guardian and their position changes.
Yeah, and also at the same time, I have to talk to the guardian, because I have to obtain their consent, their agreement to act in such a way. And over time, I will bring my kids to see the guardians, my friends, so so that they get to know each other. Yeah. So if all of a sudden I pass away, then the two guardians are not strangers.
Well, fantastic. Well, that's very good advice, very good practical advice. And on that note, I'm very conscious for everyone's time. It is approaching, we're just a little bit past the hour. I think there's still questions here, but I'm afraid, I think it's that time of the day. So I want to thank everybody for dialing in today. I want to thank Alex for giving us such great guidance, because it's not just the law. This is a very practical aspect of how to handle your wills, your guardianship of the elderly and the children. And if there's any takeaway today, if I can wrap up, I think is to get your affairs in order and get your wills in place. I think you've driven that point. In that point, the poll questions illustrates everyone may consider this, and for us to really think about what we want to do in terms of how you want your to prioritize how you want to handle your assets, be it wills, guardianship of your children, and what will happen to you if you become incapacitated. Do you have any last words to share, Alex?
I think you summarized it in a very nice way. I've got 4 bullet points here. Prioritize your will, consider trusts, etc. You are unique, and professional advice.
Oh, fantastic. On that note, I think.
Let me also thank you, the chairman, MAYCHAM, and all the co-hosts for having me today. Thank you very much.
Thank you, Alex. We should thank you. And a loud virtual applause for. Thank you, everyone. Until our next gathering at MAYCHAM. See you soon.
See you. Bye-bye.